Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome to the Baker Botts Enforcement Insider, a podcast covering the latest trends and developments in compliance and enforcement with a focus on the energy and technology industries. I am Michael Loesch in Washington, D.C., and with me today, as always, is Brendan Quigley from New York. Hey, Brendan, what are we going to get into today?
Michael, I think we're going to talk about two topics that seem to come up again and again with different enforcement agencies, whether that be the DOJ, the SEC, or today's enforcement agency, the CFTC. And those two topics are whistleblowing and insider trading. And they combined in the same case recently, which was a CFTC resolution involving traffic order trade.
Let's jump in then. A short time ago in mid-June, the CFTC announced a settled enforcement action against global trading house Trafigura for violations of the Commodity Exchange Act and CFTC rules related to three key enforcement issues and core violations. The first was manipulation in the fuel oil markets. The second was trading while in possession of material non-public information that the company knew or should have known had been misappropriated from another trading entity, and we'll dig into that one. And a first ever for the CFTC charge, impeding whistleblower communications. So let's take these three core violations one at a time. So first, let's get into the misappropriation charge. The CC alleged that the company was trading while in possession of misappropriated material non-public information. The allegations are that the company obtained material non-public information from another party outside the company that it knew or should have known was disclosed in breach of some pre-existing duty on that outside party. And the non-public information that was included in the case involved documents that contained pricing formulas that the other party was using. The other party's expected import volumes of gasoline, types of gasoline to be imported in the forward months, and destination ports for gasoline. The information included certain competitor pricing information. So the allegations are that the company's traders actually entered into commodity transactions while in knowing possession of this misappropriated information and didn't say anything to their trading counterparties about their access to the information. It's a significant charge and settlement in the misappropriation area for the CFTC for a couple of reasons. One, it's just a clear continuation of the CFTC's priority on these misappropriation / insider trading type cases. Another key takeaway here is that this is a tipper tippee insider trading case, right? So here a trader violates the relevant rules, Section 61 and Rule 180.1A1 and 3, even when the trader itself does not owe a duty to the source of the information, but the information received from another person that is a tipper. This type of tipper tippee liability is the continued expansion of the CFTC's investigation and enforcement in this area. Now, in these types of circumstances, for there to be liability, the trader has to know or should know that the tipper disclosed the information in breach of their duty to the actual source of the information in exchange for some personal benefit, and the trader has to trade in knowing possession of that misappropriated material, non-public information. So we talked about in a previous episode, insider trading from the recent cases on the SEC side, Brendan. This is an example of how the CFTC is focusing on these issues and expanding their reach. Do you have any thoughts?
We see a lot of common themes here, right? This is a tipper case. This isn't alleging that the folks at the company misappropriated this information in violation of a duty to the company, but they were essentially what we would call traditional insider trading, downstream tippees of someone who did misappropriate the information. And I think so that is something before in both the SEC and DOJ context, in the context of Rule 10b-5 under our SEC Rule 10b-5. I don't think it's notable here, that the C noted that the traders entered into transactions while in knowing possession of this information. That does mirror the FCC's interpretation of Rule 10b-5 that insider trading liability can apply when somebody trades in knowing possession of material non-public information. Not that they have to use the information. And there's some split in the case law over that, but obviously knowing possession is a lot easier to prove for the government than showing the person used the information to trade.
Yeah, absolutely. Well, we'll talk about some of the practical implications of this a little bit later, but let's move on to the second issue, which was allegations of manipulation of the Gulf Coast high sulfur fuel oil benchmark. The commission alleged that the company engaged in trading conduct during the Platts window, which was reckless as to the impact on the Platts fuel oil price assessment, and that the trading conduct benefited the company's futures and swaps positions that settled by reference to that assessment, including derivatives that were traded on U.S. exchanges. In these facts, the company held derivatives and physical positions in the U.S. that exposed it to fluctuations in the Platts price assessment for the U.S. Gulf Coast high sulfur fuel oil. And we won't go through all the facts that sort of describe the company's activities in this area, but the company transported large amounts of physical oil across the globe and entered into transactions with some of its related affiliated entities and was engaged in a program that was designed to export fuel from the Gulf Coast to Singapore to profit from the price differentials. The company held a long derivative position and a short physical position, and its long derivative position exceeded the short physical position, so that any increases in benchmark would benefit the company as a result of gains from the derivatives positions, which would outweigh the higher prices it would pay for the physical oil transactions. So the allegation is that the company bid heavily for and bought fuel oil in the Platts trading window and in amounts that were much larger than it had ever previously purchased in the window in a single month. The heavy bidding and buying activity increased the daily Platts benchmark value, which the company benefited from based on its derivatives position. So that's the allegation here. To read a quote from the order, the commission said the near exclusive use of the Platts window to source large quantities of fuel oil in 1 month departed from its past conduct, and the large volume created artificially high U.S. Gulf Coast high sulfur fuel oil benchmark values throughout the months that were not reflective of the ordinary forces of supply and demand. A couple key takeaways here. One, this is really, there's a lot of detail here, but this is really a classic cross-market manipulation case where the company was taking action in one market to obtain an advantage in a different but related market. So there's not a lot new with respect to this manipulation charge here. It is worth noting that the commission highlighted the departures from the company's past conduct and trading patterns and use that to support the manipulation charge. That's something that, from a compliance perspective, it's always important to keep in mind whenever you're deviating from past patterns. You need to pay attention to that from a compliance perspective. Anything here, Brendan, before we move on to the new whistleblower charge?
I saw the commission noted a departure from kind of ordinary trading practices or prior trading practices. In your opinion, is that something you think would be determined or assessed by some type of market surveillance, by a whistleblower, testimony or evidence, or all of the above?
I think they would, yeah, all of the above. I think they would determine the patterns based on analysis of trading activity, information which they could get from the trading venues and from the company itself, or even from counterparties, unrelated market data. But from a company perspective, it's the kind of thing where it's important that traders know that if they're going to deviate substantially from either entering into new products or new markets or significantly greater volumes or positions, that they should talk to compliance contemporaneously. And in certain circumstances, it may be useful to document the reasons for the change in pattern or change in behavior, or to do an assessment from a compliance perspective to ensure there's no manipulation risk or other disruptive conduct perspectives. Yeah, these are key fact patterns to look out for from a compliance perspective, and ones that the commission is looking for as evidence of bad intent.
Got it. So should we talk about NDAs?
Let's jump into that real quick. I think this is a pretty interesting area and something new for the CFTC. So the third charge in this matter involved an allegation that the company impeded its employees from communicating with the CFTC. So here the company had required its employees to sign employment agreements. And when employees separation agreements that included what the commission viewed as broad non-disclosure provisions that they believed prohibited the sharing of the company's confidential information with third parties. The scope of the definition of confidential information in these agreements, commission thought was broad, and that the language prohibited disclosing the information without a specific carve-out that would have expressly permitted the sharing of information with the CFTC or other law enforcement. We're going to get into this a little bit further, but one key takeaway here, as we mentioned, is this is the first of its kind action for the CFTC. The alleged violation is of CFTC Rule 165.19b, which implements CEA Section 23H(j), which makes it unlawful to, and I'll read from the statute here, or from the rule here, unlawful to take any action to impede an individual from communicating directly with the commission staff about a possible violation of this CEA, including by enforcing or threatening to enforce a confidentiality agreement or pre-dispute arbitration agreement with respect to such communications. So this is the first time the CFTC has pursued such a charge. It was not without controversy. There was a split vote here at the commission, a 3-2 vote, and some opposition statements from Commissioners Mersinger and Pham. Do you want to walk through those, Brendan, and talk about some of the issues?
Yeah, I think Commissioner Mersinger's statement was more, I would interpret it more as a textual analysis. I think you said the rule requires or prohibits taking action to impede an individual from communicating with the commission staff. And here she objected to using the rule to essentially, in her words, penalize inaction, which is a failure to include carve-out language or reporting to the CFTC. Both her statement, I think Commissioner Pham's statement, really is a question of notice, right? Really the concern is notice and this whole idea of regulation by enforcement in terms of bringing this action for a whistleblower, basing a violation of Rule 165.19b on the absence of a carve-out in the company's confidentiality policy. You wonder if this charge would have been brought if this were not part of a settled action involving other substantive violations. You know, essentially what the CFTC gets here is in the context of a larger settlement, they're able to fire a shot across the bow of other folks about what their confidentiality provisions and their non-disclosure provisions should be looking like if they're going to be regulated by the CFTC.
100%. The one key concern of both commissioners was the sort of lack of any notice that this is how they were going to interpret these provisions. So it's worth taking a look at those two statements. I mean, Commissioner Pham's statement was a little bit sharper and had a few other issues. There were some complaints about not having sufficient time to review the underlying record before voting on the matter, which is an interesting internal administrative issue that maybe is worth noting for future commission actions. And also, Commissioner Pham's statement I thought was interesting in that she raised that overall the agreements at issue actually included savings clauses that voided any language that might violate any law or regulation, whether current or prospective. Her view was, taken in totality, those documents appeared to be compliant, and that this is suggesting that there really was no need for a specific carve out. So I think that's that dynamic, and the message here is at least from the commission enforcement staff that general carve outs are not sufficient from their perspective on a going forward basis.
We've gone through criticism at the settlement, but it's not a crazy position to take, right? As much as part of this is designed to provide notice to the employees and other individuals that they can, in fact, report information.
Along those lines, just to talk about how this case resolves, the remedies in this case, there was a large penalty, $55 million penalty, and the company did agree to remedial undertakings, specifically an agreement to modify its agreement language and non-disclosure provisions in its various agreements to include language making it clear that no term in any of the agreements should be understood to limit or prevent the filing of a complaint with or voluntary lawful communication with or disclosure of information to any federal, state, or local government, regulatory, or law enforcement agencies. So on a going forward basis, from compliance perspective, as companies are looking to adjust or review or assess their own agreements, looking at the language required in this undertaking, a good guidepost to consider when you're adjusting your own language to ensure that it's going to be compliant on a going forward basis. Also, the settlement did note some remedial steps already performed by the company, including improvements to policies and procedures and additional resources and training and compliance testing and controls testing. I think that's worth noting just because that is the standard now, and remedial actions as soon as you're aware of an issue and before there's any even investigation or certainly before a resolution or negotiation of a settlement is really important. And I think the hope is that you'll get better result if you can show that you've done more on your own. And then finally, before we turn it back to you, Brennan, I just note that this was a neither admit nor deny settlement. It wasn't a required admissions case, which is something that's been at issue at the CFTC. So that's just worth noting that this was a more standard type of settlement. How does this whistleblower thing, Brennan, relate to what's been going on at the SEC and what's happening at DOJ?
I think in terms of the resolution that we've been talking about today, it echoes what we've seen in SEC cases where the SEC has been pursuing enforcement actions against companies allegedly interfering with the ability of individuals to provide information to the government under SEC Rule 21F17, which prohibits any person from taking any action to impede individuals from contacting the SEC to report a possible violation of security laws, including by enforcing or threatening to enforce a confidentiality agreement. And we've talked about this on, I think, a number of these previous podcasts, and we've also written about it. We can put some of those in the show notes, but the SEC has been pretty aggressive about what they view as things that would potentially chill whistleblower activity. And they've reiterated that Rule 21F17 is not limited to the employer-employee context. They've brought violations of that rule in the context of retail brokerage customer agreements, advisory client settlement agreement, customer agreement, and investor agreement. They also last year settled an action against a privately held company over its separation agreement. So very broadly construed by the SEC. And I think it seems like every fiscal year, at the end of the fiscal year in September, we always see a couple of these actions under Rule 21-17 just to prove the point that the SEC is still paying attention.
What about DOJ?
I mean, in some ways, DOJ had the original whistleblower program in the False Claims Act, which has been around since the Civil War. That's a civil violation. On the criminal side, DOJ more recently has announced a new pilot program back in March to offer financial incentives for individual whistleblowers to report wrongdoing to the DOJ. And also some of the U.S. attorney's offices, including the U.S. Attorney's Office in the Southern District of New York, where I used to work in the last 6 months or so, announced their own whistleblower program. And I think this is just a recognition that in a lot of these cases, whether it's CFTC, SEC, DOJ, you're talking about fraud, and fraud really depends on intent and what's in people's state of mind. And it often requires insiders to tell that story, both to prove that the individuals who are alleged to have committed fraud had the requisite intent, and also in the context of these complex transactions, again, literally tell the story, whether that be to a jury or to, frankly, the people investigating the case. So that's why I think this stuff is so critical. And I think we'll continue to see both whistleblower-initiated enforcement actions, and we will continue to see enforcement actions from similar to the CFTC and the SEC based on alleged actions that kill whistleblower activity, even in a seemingly minimalist way.
Let's wrap this up by putting it in context a little bit and then give a few practical takeaways. In terms of context, big picture here is this matter's worth reviewing, taking a look at yourself, because it does touch on three sort of priority enforcement areas. Manipulation remains a key enforcement concentration for the CFTC, and the CFTC continues to expand its efforts to investigate misappropriation of material non-public information and insider trading. And now clearly those theories include tipper-tippy situations. And with respect to whistleblower protections, enforcement related to those rules are a growing priority at the CFTC, as you said, and more broadly at other agencies. And given the reliance of the commissions and various agencies on the inflow of tips and complaints, you have to expect that will continue. So importantly, each of these areas should be a focus of compliance and training for all commodity and derivatives market participants. So, if the priority areas for the CFTC, they should be priority areas for you as well. So what are some practical takeaways in that vein, Brendan?
Yeah, I think on the whistleblower piece, it's important for companies, both public and private, to review documents across their businesses to make sure that they effectively carve out whistleblowing activities, and in particular, reporting to a government whistleblower activities from their confidentiality and other restrictions. And as we said before, this certainly includes employment agreements. It's not limited to that, though, right? It includes agreements with consultants, confidentiality agreements or NDAs with individuals, policies such as compliance manuals, codes of conduct, employee handbooks, training materials, and brokerage, customer, and advisory client releases and settlement agreements, and limited partnership agreements and other investor agreements.
Yeah, absolutely. And some of that work hopefully has already been done as a result of the CFTC's or the SEC's activity in this space for several years. But to the extent you haven't done that exercise, it's important to take a look at those agreements. And I would add that you should consider updating your training activity, even conduct specific updated training on this topic for key personnel, compliance, legal, and operational personnel. And of course, you should, where there are issues or questions with regard to assessing the risk of existing documents, determining the most effective way to look at past agreements and how to treat them, you should work with your in-house counsel and consult with counsel to work through and assess the risks there. So with that, Brendan, I think we can wrap it up.
Great. Thanks for listening, and we'll see folks hopefully at about a month.
All right. Thanks all. Bye-bye.
Thank you for listening to this BakerBots podcast. BakerBots has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on BakerBots practices, please visit us at bakerbots.com. This presentation is provided by BakerBots LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.